Major breaking news. The United States Supreme Court has issued its decision in the relentless and Loper-Bright consolidated cases and have concluded that the Chevron Doctrine, also known as the divine right of deference to the deep state and to administrative agencies, has gone bye-bye. It is tossed into the trash heap of history from where it never should have come. Great news here if you believe in freedom. Bad news if you believe in the regulatory state and if you support the growth of government run by unelected bureaucrats. Let's talk all about it and what it means for your rights and the ATF when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 Terrorist Attacks Teach Americans About the Right to Bear Arms. Check it out on Amazon if you have not already got a copy, and if you have a copy and you've read it, please feel free to leave a review on Amazon. Always helpful to show interest in a book that you write. So I appreciate that. All right, folks, this is huge news. The good news is if you've been following the Four Boxes Diner channel, you knew all about this long before anybody else did, because I explained to you that the United States Supreme Court was going to take the Chevron Doctrine and get rid of it. This is a huge deal. To begin with, the two cases that were related, one was called Relentless, one was called Loper-Bright. Doesn't matter the details of those cases. The bottom line is this. You had situations where unelected bureaucrats that work for the federal bureaucracy, they work for administrative agencies, were taking federal statutes that were ambiguous and were basically interpreting that ambiguity to give them, the unelected bureaucrats, the regulatory state, the administrative state, whatever you want to call it, the deep state, giving themselves all sorts of powers over our lives as Americans. Over all aspects of our lives, they were giving themselves powers and authorities that were never delegated to them by the United States Congress and statutes. And the way the Chevron worked was this. This is how the Chevron Doctrine worked, and it's now gone bye-bye. Basically, since 1984, the Supreme Court precedent told federal courts, starting in 1984, that if there's some ambiguity with a federal statute, i.e., if there's an ambiguity with, let's say, the Gun Control Act of 1968, then the regulatory agency responsible for administering or working under or enforcing that statute in the context of the Gun Control Act of 1968, for example, the ATF, if there is any ambiguity in that enabling legislation in the statute, then it was up to the federal bureaucrats, the federal regulators, in my hypothetical example, the ATF, to assume and write laws under the notion that that ambiguity created by a congressional statute was to be presumptively granting of additional powers to these agencies. So these federal regulatory agencies of unelected bureaucrats, civil servants, were able to expand the growth of the federal government without having to go back to Congress to get additional legislative authority by enacting new laws, let's say. So as a consequence, you had this massive growth of the deep state, of the regulatory state, from 1984 through today, in part because legal challenges to the authority of these agencies were always met in court by the agencies saying that under the Chevron Doctrine, they had to be deferred to because they were the subject matter experts on the topic. So, for example, if the Gun Control Act of 1968 had an ambiguous provision of some sort about some topic, the ATF could go to court and be like, we're the gun experts in America. We're the intellectual giants of guns and gun technology and the Gun Control Act of 1968. And we, the ATF, interpret this law in such a way that expands our power and reduces your freedom, you Second Amendment loving peon. And under the Chevron Doctrine, that kind of argument advanced by agencies such as the ATF or the DOJ, EPA, FDA, it doesn't matter, all those federal agencies. Under the Chevron Doctrine, that argument that we're the intellectual giant experts in a subject matter and you're the uneducated peon peasant serfs, therefore we must be deferred to under the Chevron Doctrine. And courts, because of the Chevron Doctrine, federal courts would defer and give the benefit of every doubt to the unelected bureaucrats in that legal dispute about the scope or a mandate of their authority. But today, because of the decision by the U.S. Supreme Court in Relentless and Loper-Bright, that deference to these agencies, to these regulatory bodies, to these bureaucrats is no more. This decision 6-3 by Chief Justice John Roberts, who expended quite a lot of political capital on this, if you want to play that game about political capital, he clearly was saving up his political capital to get rid of the Chevron Doctrine, which I can assure you is going to cause nothing but you think it was bad with how the Democrats and regulators and big government fans, how upset they were after watching Joe Biden's debate performance. You ain't seen nothing yet until you see how they react to the decision to get rid of the Chevron Doctrine, which is really a grant of power that they got from the courts without any rhyme or reason. Now, I want to let you understand one thing, conceptually how this works. If you remember from your childhood, the cartoon on Saturday mornings, I'm just a bill on Capitol Hill. Remember that one? And it says that the bill goes to the House and the Senate, and then it passes the House, it passes the Senate, it becomes a right. The bill then goes to the president who signs it, and it becomes a law. So a bill becomes a law. Here's the reason why getting rid of the Chevron Doctrine is so good for Americans and for freedom, and for those who don't like the ATF, among other things, is because what was going on since 1984 through today is that process that we learned about, that the way a bill becomes a law is through the elected officials in the House of Representatives vote for it, the elected officials in the United States Senate vote for it, and then the elected official of the president signs it. Set aside the veto issue, which we all understand. But you see what happened there? Every single part of that bill becoming a law involves we, the people, acting through our elected representatives. And if they do something we don't like, in theory, we can vote them out. We can punish them, which does happen, right? Does happen. Ask Liz Cheney how that works. So the reason why getting rid of the Chevron Doctrine is so important is because the Chevron Doctrine basically created a fourth system of government, a fourth branch of government, if you will, that said that in addition to a bill becoming a law through our elected representatives in the House, the Senate, and the presidency, you can now basically create laws by virtue of the magical waving of a wand or a fiat effort by unelected bureaucrats that just thought something was a good idea. So you have all this nonsensical laws being created by the ATF and all these other agencies in the name of interpreting ambiguities in the statute. Loan forgiveness for public school teachers that vote like 100% for the Democrats. That kind of stuff going on, right? Now the Supreme Court says, no can do. If you want to change the law, if you want to expand your powers, ATF or EPA or FDA, whatever it is, that's fine. Go to Congress and try to pass a law through those elected officials, and then you can have your authority, theoretically. But you can no longer do it on your own, because up until now, because of the Chevron Doctrine, these unelected bureaucrats have been able to make law by interpreting what they want the law to mean, by claiming that the law is ambiguous, and once they claim the law is ambiguous, they then make it up, and they say, there you have it. And then when they're sued in court, saying that they're exceeding their authority, the ATF or the EPA or the FDA or the agency that's being sued just gets to say, you have to defer to me because I am the subject matter expert, and under Chevron, as the subject matter expert in the area, it's my job to do what I think is best under the law. I don't have to go back to Congress. I can just do it as an unelected bureaucrat. But because of the Supreme Court decision 6-3, an opinion by Chief Justice John Roberts, that is gonzo. This is a very big deal, and I can assure you, you are going to hear a bunch of kicking and screaming by everyone in Washington, D.C. about how their authority and power has been cut back. And as a reminder, before I wrap up this video, I always remind you of this. It's just a good thing to keep in mind. The difference between power and authority. Power and authority. They are not the same. Power and authority are not the same. Power means I have the power over something or something. Authority means I can lawfully act over that thing. So a kidnapper may have the power over a kidnapped victim, or the hostage taker may have power over the hostage. They may have that power relationship, but they don't have legal authority. So just because an administrative agency has power over something doesn't mean they necessarily have the legal authority to act. So never lose sight of the fact that power and a legal authority to act are not always the same. Yes, you can sometimes have the power to act because you have the legal authority, but they're not the same thing. Always remember the difference between power and authority, because sometimes people exercise powers they don't have and they're not lawful. And that's what's been going on with these administrative agencies. They've been exercising powers, but they never had the lawful authority to do it. And the Supreme Court decision to cut back and get rid of the Chevron Doctrine, which I predicted on this channel and we've talked about several times, this is a perfect example of how they're removing powers that never existed from these agencies and making sure the only powers that they exercise going forward are those powers specifically delegated to them by the elected officials through the enactment of laws from the House, the Senate, and the White House, through elected officials of we the people. It's given power to we the people and taken power away from they, the unelected bureaucrats. And that is a big win for freedom. And we'll talk more about this in the future. But I wanted to give you the good news that as predicted, the Chevron Doctrine is bye-bye. And those, therefore, when these letters are sent out by ATF, they're not going to be signed to the Chevron Doctrine saying we win because you lose. That will not be an available option for the ATF, for the EPA, for the FDA, and for all these other administrative agencies working out of DC and beyond. So there you have it, folks. Hope you learned something here today at the Four Boxes Diner. Make sure you subscribe. I really would appreciate it. Don't forget to follow me on X at Four Boxes Diner, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.